So as I was saying, we've had a great treaty week. We have some great guest speakers today. Just before I introduce them and let them take over, I wanted to share with you some of our treaty books that we've been working on. So we do have our treaty history calendar that's available for download on our website. So there's 16 months of treaty history knowledge there for your viewing and enjoyment. We also have a PDF downloadable file of our treaty transcript. So this is the text of our treaty, as well as it's written in Anishinaabemoan, and it also includes our understanding of the treaty. So Chimigwech to Elder Rita Corbier for doing that great work for us. And we're going to be speaking to Rita in the very near future and hope to have an event with her as well to share with all of you. And very excited about the activity booklet that we just launched yesterday. So we created this treaty learning tool for our kids. So please feel free to download this as well. It's available on our website, and we'll soon be getting printed copies that we can share with many of our communities. So you'll see coloring pages on there and creating your own wampum, maps, word searches of our treaty signatories, our gimas today, and our land. So a lot of great activities, so be sure to check that out. So without further ado, I will pass it over to Roger and the Annuities team and Elizabeth to share with us a little bit of information about our court case. So take it away, Roger.
So what I guess people should understand is that this is a complex case, as are generally Aboriginal and treaty rights cases, and we filed the statement of claim back in September 2016. So we've already been in the court process for more than 4 years, and we're part of the way through. So, for instance, in terms of the complexity of this case, we're having to deal with it in 3 phases. And we've already gone through phase 1, which was probably the first big hurdle. And phase 1 really focused on the issue of the enforceability of the treaty provision, which relates to the increase in annuities that the treaty contains, and we were successful. The litigants were successful in having the court come to the conclusion that the provision was enforceable. And I'll explain a bit more what the issue was as between enforceability, the different perspectives taken by the parties, the plaintiffs, and of course the defendants, and that's the governments of Canada and Ontario. And then stage 2 was established to enable the Crown governments, that's Canada and Ontario, to advance their defenses, very technical defenses against the claims. And those defenses were primarily in relation to what is called Crown immunity. I'll explain that a little bit more, and or that the case and the annuities claims were statute barred, and I'll explain what that means as well. And then stage 3 will be focused on trying to arrive at the compensation. And that's not an easy task, given that many years have passed since 1850 and 1874 when the last augmentation took place with respect to the annuities payments. So there's a long period that is involved in terms of trying to establish compensation requirements, and then there's the whole issue of, well, how do you come up with a formula about arriving at a compensation value? So 3 stages, and like I said, we're partway through. We've certainly dealt with the stage 1 and stage 2 matters in a hearing context, and those decisions that have been rendered at this point are now in appeal. The stage 3 matter will be dealt with next fall. So let me explain more about where we are with respect to stage 1. So stage 1, we got the decision from the Superior Court from Madam Justice Patricia Hennessy back in December of 2018. Within a month, in accordance with the rules, and of course the decision was in favor of the plaintiffs, the First Nations and the First Nations beneficiaries. And the decision basically affirmed that the Crown has a legal treaty and fiduciary obligation to increase the annuities above $4 per person. $4 being the current value of the annuity which the Robinson Huron Treaty annuitants receive annually. And so within 30 days, Ontario filed their notice of appeal, and in going through the reasons for their appeal, it helps with understanding what was the nature of the decision, what did the decision say. So one of the points that the Government of Ontario advances is that the judge erred in law by interpreting the treaty as requiring a mandatory increase above $4 on the basis that she did not properly consider Crown evidence. And that goes to the point that in the treaty, the provision about the augmentation of the annuity, the annual annuity, is written in a way that there is discretion that the language uses, in that it says that Her Majesty may be graciously pleased with respect to increasing the annuity. So the words imply a discretion. Of course, the plaintiffs advanced evidence which would be contrary to the notion that there was any discretion. The Government of Ontario also alleges that the language in the treaty establishes a $4 cap, and that's why, you know, the annuity has been $4. Of course, the plaintiffs took a different position on that the intention in the treaty was to acknowledge that the treaty territory was probably going to undergo development, resource development, and that was probably going to generate revenues, and that if the revenues generated were such that there would be a net profit by the Crown, that the annuity should be increased. Ontario also alleges that the judge erred in finding a fiduciary obligation. One of the arguments advanced by the plaintiffs is that the Crown does, you know, have a fiduciary obligation generally with respect to Indians, and in this case that the fiduciary obligation also applied to their obligations and commitments and responsibilities in relation to the promises in the treaty. They also allege that the judge erred in not finding that the Crown has total discretion regarding increases. That's the point that I alluded to earlier. They believe that the language is pretty clear about there being a Crown discretion, and that they simply exercised the discretion not to increase the annuities since 1874. And at the outset of the case, going back to September 2017, Ontario had made an adjustment to their statement of defense, and they in fact suggested that while they don't have an obligation to increase the annuities based on resource revenue sharing, they suggested that perhaps they should have increased the annuities anyway based on having to index the annuity payments based on inflation, cost of living, so on and so forth. And in the judgment, the judge rejected that argument that there was an implied requirement on the part of the Crown to increase the annuities, because that would have perhaps relieved them of the obligation to increase the annuities in relation to resource revenue sharing. So the judge rejected that argument and said they couldn't imply that as being a term of the treaty. Now that appeal was filed. The federal government did not agree with the appeal. In fact, they disagreed with the appeal, and they are arguing that the judgment of Madam Justice Patricia Hennessy should be affirmed, and that what the federal government is arguing is that the parties really should turn their attention to negotiating some kind of an agreement to address the issue of arriving at a compensation figure. So this appeal was originally scheduled to be heard earlier this year. It was scheduled for May 2020, but then of course COVID-19 displaced the hearing dates, and now the new hearing dates are in January of 2021. So in a couple of months, the parties will be at the Court of Appeal in Ontario to deal with Ontario's appeal. And there are interveners from other parts of the country that have asked to have standing in the appeal so that they could make their own legal submissions regarding the outcome of the trial judgment. So the hearing will open up on January 5th with opening statements to be made by all of the parties, and then the hearing will continue from January 11th to 14th as week 1, and in week 2 from January 18th to January 21st. The hearing will continue. The reason they require all of this time, of course, is because there are many parties. Aside from the Robinson-Huron Treaty plaintiffs, there's Robinson Superior plaintiffs, there's 2 Crown government defendants, Canada and Ontario, and there are a number of interveners that also will have the time to be able to make legal submissions, and all of the legal submissions will be dealt with by a 5-judge panel, and of course all of those 5 judges have the ability and opportunity to question the parties. So that's why there's that amount of time dedicated. And it is our understanding that these proceedings will be streamed. So there should be access for those that are following the case and are interested in the case to see the proceedings at the Court of Appeal. For those that followed the case from the beginning, the trial was live streamed, and there is a record which is still accessible for those that that want to view the stage 1 proceedings as well as stage 2. So moving on to stage 2, as I said, stage 2 was primarily about the defenses that Canada and Ontario are relying on to defeat the claims of the Robinson Huron First Nations, and that decision was rendered at the end of June this past summer, and again the judgment was in favor of the plaintiffs, the Robinson Huron leadership and beneficiaries. In stage 2, Ontario had argued Crown immunity from liability for breaches of fiduciary duty prior to the enactment of the Proceedings Against the Crown Act in 1963. Justice Hennessy ruled against Ontario on this. The judge also ruled against Ontario's argument that the treaty annuity claims were barred by limitations statutes. Normally, statutes of limitations, can establish specific periods, 2 years, 20 years, for people to advance their legal claims, and if they don't, well, then the statute bars them. So that was one of the arguments that Ontario advanced. And as in the first stage, Ontario is appealing stage 2, and so the points that they base their appeal on is that the judge erred in law by concluding that the Crown is not immune from claims for breach of fiduciary duty prior to 1963. They also allege that the judge erred in law by finding that Ontario's limitations legislation does not apply to the plaintiff's claims. They're also questioning the judge's decision to apply principles of statutory interpretation which are favorable to First Nations, especially in cases relating to treaty. And those were set down by a case in the Supreme Court of Canada in 1983 in a case called Nawagijik versus the Queen. And also alleging that the judge erred in principle by relying upon and interpreting the principle of the honor of the Crown to render a provincial statute and common law rule inapplicable to the treaty claims. For the most part, the issues on appeal really focus on the issue of Crown immunity and the statute of limitations, and as I said, in both of those instances, the judge ruled against Ontario in trying to advance those defenses. So this hearing is now the hearing for stage 2. The appeal of stage 2 is scheduled for June 1st, 2021. So stage 1 is in January for the appeal to be heard. Stage 2, the appeal will be heard in June of next summer. The stage 3 hearing is scheduled for September 2021. So all of this case obviously is going to be very active, starting in January of 2021 with the stage 1 appeal, June 2021 the stage 2 appeal, and then September 2021 with stage 3. And the stage 3 hearing, which of course has its own complexities, will focus on remedies, including compensation for the Crown's failure to augment the annuities in the past. And there will be a number of questions that'll have to be addressed, including what are the actual net Crown revenues generated from resources in the treaty territory from 1850 to the present day. That's obviously a difficult task. What is the value of the resources in the treaty territory from which the Crown generated revenues in that period? And number 3, what is the fair share of those revenues that ought to have been allotted to the Rumson-Huron Treaty beneficiaries as augmented annuities from 1850 to the present? So there's important issues. There's important evidentiary requirements. That's a long period of time in which to try and come up with information about the value of resource development, and of course we will need to rely on experts to be able to do this, which will include economic experts. And it'll require experts on the part of the Rumson-Huron nations as well, by way of elder testimony with respect to the expectations around, let's say, perhaps the issue of what is the fair share. And so the hearing will take place in September, but there's a lot of preparatory work which has started, and there's a list of dates where documents have to be filed, documents have to be exchanged, reports from experts have to be filed, and of course, you know, there's a requirement on the part of the defendants to file their reply evidence based on what the plaintiffs, the Rumson-Huron First Nations, will be submitting. So that's the update in terms of where we've been and where we're going in furtherance of the litigation. So I'll leave that at that for now. And I believe there will be a period for questions and answers, and I'm going to leave that in the hands of the moderator. But one of my tasks right now is to introduce Elizabeth Carlson. Elizabeth is a professor in the social work department at Laurentian University. And she and students connected to her have been busy over the last few weeks, and it may have been longer. Elizabeth is going to provide some historical context to what she's speaking to, and she's going to speak to the development of a petition, and I'll leave the details to her.
Okay, well, I'm so happy to be here today, and I'll just introduce myself a little bit further and tell you a little bit of the story from my perspective of how the petition developed and all of the people that have been involved. So I'm a settler scholar, and I've almost always lived on Anishinaabe territory throughout my life, in Minnesota and in Manitoba, and now in Sudbury. My scholarship focuses on decolonization and on how settlers can place themselves under Indigenous sovereignty, and also on social change. So I moved to Sudbury to take up my job at Laurentian in 2017 in the summer. Well, actually, I moved in October, but I started the job in the summer. And when I lived in Manitoba, I started to learn about the importance of treaties, and I was involved in different activism events around I Don't Know More and things like that. And I started to understand that how important it was for me to be aware of the benefits and the obligations that I have as a treaty person. I also learned that many times Indigenous perspectives on treaties include the making of kin or the making of relatives through the treaties. So I started to think about myself as a treaty relative and think about how can I be like that kind of relative that you would want to have. So I started working on that. So once I moved to Sudbury, then I said, well, now I've got to learn how to be a good treaty relative in a whole new territory with a different treaty than what I was working with in Manitoba. So right away, I started asking questions. Like right when I got to Laurentian, I started asking questions. Who can I talk to about the treaty? Who can I learn from? And I was really lucky that there was a number of events that happened at Laurentian around treaty, and there were a number of people that I could talk to start to learn. But it's a pretty big job learning about a treaty and learning how to understand the treaty. And of course, the text that like the government version of the treaty is like I didn't really have a lot of trust in the way that it was recorded, but I also didn't have a way to access, a very easy way to access Indigenous treaty perspectives on Robinson-Huron Treaty of 1850. So I was working on that, trying to figure it out. And so I also attended 2 Robinson-Huron Treaty gatherings in Shawanaga and Waquamakong, and I certainly would have gone this year, but I think it was canceled due to COVID. I kept looking for the information, so I'm assuming that's what happened. So there was something that happened at the treaty gathering in Shawanaga that I want to mention that made a big impression on me. But first of all, the beautiful hospitality and warmth of everyone when I went there, because I went by myself. I might have been the only white person there. It seemed that way to me. People were so warm, and I just thought it was so lovely the way I was being fed and offered this little gift packet. Like it was just wonderful. So, but when I was in Shawanaga, and of course, I don't really know very many of the people involved. I don't know the chiefs at this point. I really don't know what's going on. But one of the people who was talking, I think I went during a day when mostly the chiefs were taking turns talking. And one of the chiefs, probably those who are here know who it was, but because I was so new to everything, I didn't remember the names. But shared a metaphor about that issue of how there was like really hardly any non-Indigenous people present, and it was a treaty gathering. And he said it's kind of like there's a couple that's celebrating their anniversary, and one of them is off cheating. So I felt like, oh, that's my side of the treaty that's off cheating, and I thought, we got to do something about that. Like, that's not right, So that made a huge impression on me. And I said to myself, I'm going to attend as many of these gatherings as I can. And I'm going to, try to spread the word about the gatherings as well. So that was one, a little bit about how, why this became important to me. So the other thing that happened at the Waquamakong gathering is that, there were presentations about the case made at that gathering as well. And that's when I heard that Ontario was planning to appeal the Phase 1 decision at that time. And so for me, I was really upset about this, because I said, here's the Crown that's supposed to represent my side of the treaty, and they're not honoring their commitments, and they're undermining their honor. They're undermining the treaty, and they're using tax dollars to fight First Nations people and to fight against having to uphold their commitments. So I was really upset about this, and I kept thinking, what can I do about this? And I thought about it, and then, got busy with other things. But then when I heard that the Phase 2 decision had come out, and that's kind of the court case came up front and foremost in my mind again, I said, well, let me just think about this. What could I do? And I thought, what would I want to see happen? And one of the things I wanted to see happen was that more non-Indigenous people became aware of the case. like it became aware of the treaty, became aware of, the importance of the treaty and the treaty benefits and obligations that we have and all of those kinds of things. And then I said, I want Ontario to like abandon its appeal. So those were the two things that I was thinking of. And so I came up with the idea of maybe an online petition, because I'm on these listservs for these social justice petition sites, and I get them all the time coming through my email. So I thought, what if there was like something like that for to demand that Ontario abandon its appeal. So I thought about that, and then I thought, well, let me contact, like really my only contact at the time was Mike Restool, and of course he's like one of the best contacts for this kind of an idea. So I contacted Mike, and then I think he was running the idea by a number of people, and then he got back to me and said, well, like go ahead and draft something, and let's see where we can go with it. So I'm one of the courses that I teach at Laurentian is a social change course. And so I thought, why not see if any students want to get involved? So I sent an email to the students, and two students responded that, that they really wanted to be involved, and that was Jamie Lee Letourneau and Amanda DeForge. And so all three of us set about, like, we really had to, like, even though I had vague ideas about what the case was about, just from attending different things, but I still didn't really understand it very well. So we set about doing as much research as we could, figuring out, kind of what's going on and what the petition should say. And kind of, eventually it took us a long time, but we came up with a draft, and then we shared it. With Mike, and Mike had put me in touch with Roger in the meantime, and Roger had helped with some ideas. And then, like once we had our draft, then this was shared with several people, including Roger, including Sarah Harney, from the Media Style, I think is the name of the company that's doing the media around the case. So then, they helped us to revise it to make it a bit more accurate, even though we thought we had it accurate, but it's all complicated. And then Sarah helped to organize it for kind of impact and how petitions often read. And then in the meantime, I reached out to Jamie West, who's the MPP for Sudbury, because I was aware that he seems pretty progressive. I see him a lot of events. I'd seen him at like Wet'suwet'en demonstrations and different things like that. So I wanted to talk to him because, like, honestly, I'm not really an expert on the Ontario government and how it works and who the different people are and who do you target with this kind of petition. So because he's part of the Legislative Assembly of Ontario, I wanted to see what he thought about who we should address the petition to. And so he graciously met with me by Zoom and gave me lots of ideas. And one of them was, he said, you could write a paper petition, because apparently the government of Ontario has really old rules about petitions, and it has to be like actually what you turn in has to be the actual paper that people sign with their own pen in hand. So there's nothing with digital petitions for them. And that was our idea for our petition, was the online version. So he said, if you do a paper and pencil petition, if you give that to me, he said, then actually the rule is that they are bound to read that in Queen's Park, even if there's only one signature on it. So I thought, well, I think we can get more than one signature. And, it's COVID, so that makes it hard. But, I sent this paper petition, asked my students, print it out, see if you can get your family to sign, and then, if you want to come and drop them off, like that was our plan. So then, so one of my students, who her name is Holly, that lives in the residence, she got quite a few signatures for that one. So we turned those into Jamie West and said, can you please have this read during Treaty Week? So he did, and he's been so supportive. And I think we're going to watch a video in a little while of his reading of this petition at Queen's Park. So so I guess I really want to emphasize how this has been such a team effort, with Mike, Roger, the Treaty Trust, Robinson Huron, Wawinda McGaywin. I've been working on that one. with Amanda, with Jamie Lee, with Jamie West, and others. Like I know there's a number of other people sitting at different tables and different meetings that have discussed the petition and wanting to make sure that it can move forward in a good way. So we're just really grateful for everyone, and for me, it's like really important to have an opportunity, because for a long time I've been thinking like, how can I be this good treaty relative? And like finally there's an action I can do, you know, like as much as I've been trying to learn, but I wanted to do some action too. So we've got the video with Jamie West reading the paper version of the petition, and then we've got our online petition, which last time I checked had almost 750 signatures, but we would really like to see a couple thousand, I think, before we deliver it to the government representatives that we're targeting. Like I just want to put that plug in for, you know, we'll share the link for the petition, and if everyone is willing to sign it, to share it through all your networks. And also, you know, like we have a link in the petition where you can see a template for what you could say if you were calling one of those government officials, or what you could, or how you could word an email to them, just like an idea, an example. So it would be really easy for people to kind of copy and paste that in and actually do those contacts. And I think that that would really be effective, because what Jamie West shared with me when I met with him was that, you know, like those are actually really effective. If their emails and their phones get flooded with people really concerned about certain issues, that people tend to take that seriously. Especially, he said, if you word it emphasizing that this is a voting issue for you. So those are some of the ways that, you know, if people that are listening are wanting to help, like I would really request that you could take those actions. So I think we're going to probably show the link on the screen here, and then also the video. That's really all I have to say. Like I'm happy to also take questions and whatever time we have left.
Petitions, the member for Sudbury.
Thank you very much, Speaker, and I want to thank Laurentian University and University of Sudbury, in particular Dr. Elizabeth Carldon-Manathara and her students Amanda DeForge, Jamie Lee Letourneau, who are students at Laurentian University, for creating this petition. It's been very successful on change.org. This is the paper version of it. It's to the Legislative Assembly of Ontario, whereas treaties are living promises by the Crown and First Nations that are part of the constitutional fabric of Canada, and that outline mutual obligations and benefits for respectful coexistence in shared territories. And whereas the Robinson-Huron Treaty promises annual compensation, known as treaty annuities, for the sharing of lands, resources, and wealth created to First Nation treaty beneficiaries, and while a provision was included in the treaty to ensure the annuity amount increased as resources revenues increased, the annuity has only been increased once in 1874 from $1.60 to $4 and has not changed since 1874. And whereas the failure of the Crown to live up to the terms, spirit, and intent of the treaty prompted the 21 Robinson-Huron Treaty First Nations to file a statement of claim in 2014 to the Crown, both Canada and Ontario, and whereas the Superior Court of Justice Judge Hennessy ruled in the first two phases of the case that 1, the Crown has a mandatory and reviewable obligation to increase the treaty's annuity when economic circumstances warrant, and 2, that the provincial government of Ontario and the government of Canada were jointly and equally liable to respect the treaty. And whereas the province of Ontario maintains the treaty commitments remain valid today and states that it is, in quotes, working to rebuild trust and relationships with the treaty partners and Indigenous peoples, end quotes, and yet in contradiction to these statements, Ontario plans to spend taxpayer money to appeal Superior Court of Justice Judge Hennessy's decisions, fighting First Nations and fighting against the honourable fulfilment of treaty obligations. And whereas the Government of Canada has chosen not to appeal Judge Hennessy's decision and has asked that Ontario's appeal be dismissed, and the 21 Treaty First Nations have waited long enough for justice. We, the undersigned, petitioned the Legislative Assembly of Ontario to ensure that the Ontario government honours and upholds the Robinson-Huron Treaty by abandoning its appeals of justice, Patricia Hennessy's decisions in Phase 1 and Phase 2 of the Robinson-Huron Treaty Annuities case, and engages in good faith negotiations of the terms of just compensation. This being Treaties Recognition Week, I will fix my signature. I support this petition. We'll provide it to the clerk.
Hello again, and just a couple of final thoughts from me about the case. First of all, if if you get a chance to read the judgment, which is dated, December 2018, and you can probably find it online, Google it, and write in Restool versus Canada, and it probably should take you to a link where you can access the judgment. I would encourage you to read the judgment because it's not your typical very dry and boring judgment. The judgment and the justice who wrote it, it tells a story, and it's a story that begins a couple of centuries ago, 3 centuries ago, about the establishment of the relationship between the Anishinaabe and the Crown, and that relationship is partly defined by the Robinson-Huron Treaty, and so it is very educational and very informative, and it is a good read. And anybody that's interested in history and is interested in appreciating more what the relationship is, then I think you will benefit significantly from reading the judgment. As I said, into the future, as the hearings take place at the Court of Appeal, with respect to stage 1, stage 2, and probably stage 3, you can access the proceedings via live stream. And so I would encourage you to check on the websites of Robinson-Huron Wawi Namagiewin or the Robinson-Huron Litigation Trust Fund. They have websites and they have Facebook pages. So just stay tuned. I'm sure the information will be made available on those sites for you to access live stream and be able to get right up to date on what's going on. So that's it for me, and miigwech to Robinson-Huron Wawi Namagiewin, and thank you to Elizabeth Carlson and her students and the tremendous work that they're doing to support the Robinson-Huron Treaty beneficiaries. Miigwech.
Yeah, I guess I would just say too, Roger just mentioned Robinson-Huron Treaty beneficiaries, but one of the things that I try to keep foremost in my mind is that I myself and other settlers are the biggest Robinson-Huron Treaty beneficiaries because we wouldn't be able to live here if it wasn't for the sharing of the First Nations that are signatories to the treaty. So I just like to keep that perspective for myself, but I just would say it's just been such an honor to be able to do one action, and we hope it's going to have an impact. I don't know, at least we think it has an impact in teaching more people about the treaty and about the case. I don't know how responsive the government will be, but at least we're putting the pressure on. So I guess that's all I have to say. Thank you so much for listening, and thanks for having me.
Okay, well, miigwech, what a great discussion. Miigwech Roger and miigwech Elizabeth for all the work that both of you guys have been doing to contribute to our court case and the awareness, and with the petition. We were able to pull it up, so we will share it on our page. I'm just going to say some kind of closing comments. And then Nikki is still going to try one more time to play the petition video for you guys, so hopefully we'll get it to work. That would be the Jamie West video. If not, we are also going to close it up today with another video. We did have some guest speakers in. So miigwech Roger, miigwech Elizabeth, if you have any questions about the annuities or the court case, please feel free to reach out to us, email us, check out our websites. My email is Cheryl@wawindamageowin.com. And yeah, miigwech, it was a great treaty week. We had so many great events, and we're so happy that you all could join us. Feel free to check out our website, because all of our videos, all of our discussions, all of our treaty talks, our armchair sessions, our lunch and learns will be available for viewing. So it's a great way to share treaty knowledge. Please keep liking, sharing, and enjoying all of our videos. So Bama P, Nikki's going to try to roll to the Jamie West video. And then we're also going to play a video from residential school, our residential school survivors that came and shared with us this week. So I hope you enjoy. Bama P and everybody enjoy Treaty Week. That's a wrap. Miigwech.